All right, here it is, February 14th, 2024, and we're back for our second edition of unCOMPlex. The emphasis on comp and complex. And I'm going to be working on keeping my eye on the chat. If anybody has any questions they want to address, that'd be great. If not, we're going to put this out there and put it up for download. So announcements, what's going on anytime soon? Boy, an awful lot. On the 23rd of February, I will be in Fort Lauderdale with the Broward County Bar Association. They're hosting their umpteenth annual Broward County meeting. It's always well attended and a good crowd. I'm looking forward to that. Also present that day that I'm certain of will be Judges Ring, Lewis, and Forte. I say them in that order because I usually go alphabetic, but that means somebody's always last. So this time I go opposite alphabetic. Anyway, I understand some of the Miami judges and West Palm judges will be there also. So if you're there and you see me, I sure would like to meet you and have a chance to chat. Look forward to that. We will be on March 1st in Tallahassee, and that will be the annual OJCC Education Seminar at the First District Court of Appeal. That's an all-day event. Several people have asked if that will be available streaming. It will not be. There's a good chance some of it will be available streaming afterwards, but not day of, certainly. We'd love to see you in person at the First DCA. We start that morning about 8:30, and it'll be a great day. It always is. Getting into March further, on March 28th, we will be at a meet and greet with the Florida Bar Workers' Compensation section at the Miami District Office. And the address for that, of course, is on our website, www.fljcc.org. We will be the very next day, March 29th, at the West Palm Beach District Office. And these are just the meet and greets that have been inspired and sort of what's the right word, encouraged or promoted by our section chair, Paulo Longo. And I just can't say enough positive about the experiences. I think we've had a lot of great opportunities to hear people. I think folks have had a great opportunity to see each other. And frankly, folks, there's way too much of this video that's going on. And I wish that we could get back to a little bit better experience with the programs being in person and us being able to shake hands and be together. I think it's important for our community. So I look forward to seeing you 28th or 29th in West Palm Beach. Of course, in April, April 18th and 19th, we'll be at the Forum in Orlando at Champions Gate. That's going to be an excellent program. For the first time at any forum, we're going to have the statewide nominating commission meeting. We'll be on Friday that week at the forum. And so that information is also posted on the website in terms of the judges that are up for reappointment. But if you've never been to a nominating commission meeting, this is a great opportunity, and we think you might enjoy watching the process. The commission's gotten very large, so we used to have 15 members, and we wouldn't generally get all of them at a meeting, but now we've got 18 members, and the size of the commission, of course, is dictated by the number of district courts of appeal. And so 18 people in a room can be a little bit difficult to watch, but we had a great meeting in November and got a nominee for Miami out of it, 3 nominees rather. And despite the sort of large group of people, I think it went reasonably well, and we managed to get the business done. I'm looking forward to seeing more of them in the same room together at Champions Gate. And we'd look forward to seeing you there too. Also be a great opportunity to see the inside of the process. I'm just going to mute some of these calls so that we don't get interrupted. If you've got questions, I'm happy to take them, though. Just jump into the chat room and type anything that you'd like to talk about, and we'll be happy to get to those. Finally, last thing I would just give you as an announcement is the judicial survey, annual judicial survey that we do with the workers' comp section is in process right now. It's not ready for deployment, but it's in process of being programmed and put together. We hope to launch that in April, perhaps early May, but we're looking for April. I appreciate everybody keeping their eye out for that. We need more responses on that. We've done away with the comment section on the survey. Some of you have probably noticed that in last year's iteration. Well, the comments are troublesome, and we have some keyboard warriors out there that are not so, shall we say, professional in their comments and their thoughts. And so we've done away with that sort of comment process. If you've got comments or suggestions, you're welcome to call me anytime. You're welcome to reach out to me by email, reach out to me on LinkedIn, reach out to us on Twitter. We're in all these places, and if you don't understand how to get to those places because you're a social media neophyte like I am, then pick up the phone and give me a call, and I'll do my best to converse with you and see where we can get on the same page or find out at least where we are having troubles and difficulties. What's been going on that we could talk about in the world of comp? We're seeing, for some reason, an increase in the use of the word dropping. I have no idea what a dropping is, but we've got some lawyers that are periodically filing notice of dropping a party, and that's got no legal meaning that we can find. So, boy, if you've got you've pled or impled somebody by filing a petition against them or a motion for contribution, and you don't want to pursue that party any longer, file a notice of dismissal. Dismissal's got a legal meaning. Dismissal means they're free to go. Dropping a party, I don't know, it almost sounds like that crazy old bit from 1950s television where the guy screams about how he dropped the baby. I don't know what that means. So if you're asking us to understand what it means, if you're going to use dropping, tell us what you mean by it. We want to get the process correct, and we can't do that if we're not getting clear communication from you that hopefully we can understand and sort of deal with. Also, lately I'm seeing a fair amount of folks that think they would like to depose one of our state mediators. And so we're getting subpoenas for state mediators. We're getting emails or letters from folks saying so-and-so would like to take your deposition. And we're not sure why. Those requests and subpoenas are not providing any edification about what the purpose or the point of testimony might be. I accept that there may very well be good reasons why we might take testimony from a mediator, maybe for a ministerial task like authenticating a signature. I would hope that that the parties in litigation are not arguing over whether a document is or is not authentic, particularly when it's got their own signature on it. But if you need a mediator's testimony to authenticate a document, or if you need us to put such an agreement under seal to help you with authentication in terms of admissibility to hearing, reach out to me or reach out to the clerk's office. And we're happy to work with you on getting you a copy under seal to help you move forward, not take the time of the mediator. I'm not sure what else a mediator would testify about. I'm pretty convinced that the statute is clear in terms of the sanctity of the privilege of the mediation process. Now, that's not to mean that, or mean to say that there's no arguments. There certainly could be a good argument made. We'd like to hear that argument, but simply sending a subpoena to the mediator and saying you're going to show up and testify just leaves everybody with questions, and the questions need to be answered. So another thing that's troubling with that is a lot of these requests we get, subpoenas and emails, folks are not copying the opposing party. So I guess we're going to be under the impression that there's no objection to something like that. But I'm troubled when there's no notice to the other party that's obvious or patent on the cover. So I'm not sure the other party knew that you were working on a subpoena or had sent this request. And so how is the judge to decide whether the due process concern has been met and then how to rule on such an instance and to move the case forward. That's a little bit, I don't know if troubling is the right word, but it's confusing at the best. And we've got to work through and try to figure out how to deal with that. The more explanatory you can be, the more upfront you can be in those kinds of requests, the better it is for us, because it helps us to move forward without the potential challenges of reading your mind. What else have we got going on? Here recently, we've had some folks talking about the petition process. I'm not sure that I'm clear on what the discussion is about, but it has some relativity to the folks being included on a subsequent petition or not included. Uh, the need to, folks, pay attention to what's going in the petition. That document's coming up on the screen, and whether you're doing the filing yourself, which I would hope you are, or if you've got staff assisting you, I would still hope that you're reviewing that, as the supervision rules of the rules regulating the Florida Bar says that we're going to be. I hope that the lawyers are looking that material over, and the time to notice that there's a flaw, that there's a party named that shouldn't be, or there's a party missing, that's at the submission point. And if it's not, if you notice it the next day or 2 days later, we certainly don't have any problem with you bringing it up then. That's a good time to file a motion to supplement, or a motion to dismiss a party, or a voluntary dismissal against a party. And you can clean that up when you notice it. Or you can wait for that party to have to get an attorney and to file a notice of appearance and to file a motion or an objection. And if you really want to be dilatory about it, you can wait and have the judge schedule a hearing, and then you can attend the hearing, and then the judge can enter the order that says this party's dismissed based upon the fact that the attorneys showed up at the hearing and everybody admitted that the party should be dismissed. That's a little frustrating when you get to a hearing, because frankly, when we get to a hearing, we think that there's a dispute. We think that the parties need us to intervene and to do something. And so we're looking to kind of show up and do something. And when the parties show up and say, well, Judge, we're all holding hands and singing together here off the same music, the question is sort of why? What are we doing here? So if you all can communicate with each other better, more frequently, if you can communicate with each other more thoroughly, I think it would help all of us in terms of doing a better job, a more consistent job, and saving each other's time and effort. And efficiency really is going to become increasingly important as time passes. I got off on a tangent here recently about artificial intelligence. I don't know if any of you are paying attention to artificial intelligence, but your Supreme Court is in Florida. Some of the various appellate judges around the state are paying attention to it. And some of you are probably already using artificial intelligence. I cracked a joke at a public gathering about the use of artificial intelligence, and I had a very intelligent individual in the room point out that perhaps all intelligence is artificial. It was good for a laugh. At least at this point, we don't have any mandatory disclosure on the concept of artificial intelligence. But it's no different, I think, at this moment, folks, than the rules regulating the Florida Bar that say that the lawyer is going to supervise staff, the lawyer is going to review staff's production and efforts, and the lawyer is going to be responsible for what's being culminated, put together, and filed. Well, I think the Supreme Court's opinion is reasonably clear that they expect the same regarding lawyers engaging artificial intelligence, that you're going to keep artificial intelligence from disclosing your client's confidences, well, the same way you would tell your staff not to disclose them, that you're going to be careful in terms of verifying and back checking what artificial intelligence produces. No different than the way you would do that if your staff produced a pleading or some other document. It looks to me at this point like the Supreme Court's taking a pretty moderate view of artificial intelligence. I was very fearful, I'll admit to you, at the outset that we were going to see some degree of, if not panic, alarm over artificial intelligence, and people were going to be screaming about how we shouldn't use it. I personally think that that's short-sighted. I think we probably should be using it. I think if we choose not to, and we let it continue to develop and evolve without our involvement, uh, we're going to find that it comes around and gets us in the end anyway, and we're going to find ourselves behind the curve with it and not so able to leverage it and to take advantage of the things that it could do for us and support us. So I encourage you, if you're not using it, if you don't understand it, the time is now. There's a lot of good basic stuff out there that you can be watching, that you can be listening to, and you can start to figure out how artificial intelligence can get you started, um, or if you prefer, how artificial intelligence can help you finish up. Uh, Folks think about it as a research tool, but you can literally take your own document, your trial summary that you have prepared, and you can plug it into some of these AI engines and ask the AI engine to evaluate your writing for clarity and for purpose. You can get suggestions on how to smooth out those dangling participles or those difficult grammatical challenges that we sometimes face, and make the document more readable. And readability is pretty important when you're dealing with a judge that's got a busy day in front of her or him, and they don't have time to go looking up words you use on the internet or in the dictionary. So AI can be very powerful and I think very useful to you if you decide to let it in. That said, I will tell you right up front, you can't count on the accuracy of what's coming out of AI in terms of research and in terms of data. I'm not saying it's all wrong. I'm saying you've got to back check it because there's stuff out there that is wrong. AI does what we call hallucinating, where it comes up with answers to questions that don't always track. Uh, I know a fellow that put in a query about nationally who's recognized for their knowledge of workers' compensation, and got back some responses that were pretty anticipatable. Um, One of whom is a judge I know in another state. The problem with the answer was that AI named that judge, was very complimentary of that judge, but said that he was in a state literally 1,000 miles away from the one that he's got expertise and experience in. That's hallucination. Um, I talked with him. We still can't figure out why on earth the AI put him in that state, but it's just going to be those kinds of mistakes that are going to be there to be prone to cause you problems. We continue to have problems with changing people's testimony. I'm struggling with that. I don't think there's a lawyer in the state, perhaps there's not a lawyer in the world, that would take someone's deposition testimony and go in with their handy ink pen and mark through and make corrections in what somebody testified to, and then without letting the witness look at that or sign that, which is a right you have under the rules, then file that deposition as evidence in a matter. If somebody thinks that's appropriate, I would love to hear from you because I really would like to hear the other side of it. I'd like for you to educate me on why that's appropriate. Um, well, strike that. It's not depositions, folks. It's affidavits. An affidavit, however, is really no different than a deposition. It is sworn testimony. So the client comes into the office and signs an affidavit, whether that's in support of a motion for summary final order, whether that's in support of a motion for attorney's fees, whether that's an affidavit in terms of a settlement to say I don't have any child support. An affidavit is an affidavit is an affidavit. It's sworn testimony. And after the person signs it or delivers the testimony, it's not appropriate for the lawyer to go in and make unilateral changes to that document. You're changing someone's testimony. You're changing it without their knowledge, and then you're filing it with the tribunal with the purpose and point of you filing it perhaps being that the judge is going to rely upon it and make a decision. Um, that should probably bother everybody. Where is our due process? Where is our legal system if folks can unilaterally make changes in sworn testimony and file that in support of the judge making a decision? I would hope that that worries you and disturbs you. If it doesn't, and there's a good reason for folks doing that, I really would love to hear from you. I need to have one of those things come up on the screen where you can call my 800 number. I don't have that, but you're welcome to give me a call. Um, you can literally reach me anytime that you'd like to at 850-972-8915. That's 850-972-8915. And if I don't answer, I'll do my best to get back to you. Please leave a message. You can text to that number as well if you wish. Or you can email me, judgelangham@yahoo.com is the easy one to remember. But my other one is david.langham@doah.state.fl.us. And I would love to hear from you on these kinds of points. Back to child support, I've reminded myself of the issue with numbers. The numbers that you get for child support are almost incessantly changing. We get that. We hear from time to time from injured workers that say that the numbers are frankly wrong. They're mistaken. We have no way to decide that or to determine it. We are not charged with determining the amount of child support that's due or the amount that should be recovered that's overdue. All we can do is rely upon what the clerks of courts and the Department of Revenue in Tallahassee give us in terms of how much somebody owes in child support. You can file a motion with the comp judge and say, well, judge, it's not right. Judge, it's incorrect. But how can the comp judge make a decision on that? You might provide some testimony, some evidence. A judge might take that testimony or evidence and might, under that circumstance, not make a decision about the child support that is due, but might decide your child support arrearage and the recoupment from a settlement based on that testimony. But without some evidence to the contrary, I think you're asking for an awful lot from the judge. And we do have people that ask us to ignore the fact that there's an arrearage. And they say there is no arrearage, the Department of Revenue is wrong, and you should disregard what they say and do what we argue instead. And there may be judges that buy into that, but I would caution you not to be too upset if a judge does not buy into that. Your proper course is to go see the circuit court and talk to the circuit court that entered that child support order and ask the circuit court to alleviate the pressure, if you will, or to rectify the dispute or the problem that someone's having. That's much more comfortable, I think, in the long run. And frankly, it's much better in terms of the overall resolution of the case. I would think particularly for the employer carrier that might find themselves post-settlement still on the hook to pay some child support. And most employer carriers, I think, that settle cases are somewhat interested in having the finality that comes along with settlement. So if they're still on the hook, that finality's a bit at risk. I'm checking over here for the chat room, and we're seeing no questions pop up. So I'll encourage you again, if you've got specific questions we can address, I'd love to hear them or see them, as you will. What are we going to be talking about next week in Fort Lauderdale? Just to give you a sort of a taste of what's coming. The real point that folks seem to be interested in is what are the numbers looking like? Petition volume is certainly up in 2024. And I know your first reaction is probably, how can he possibly know that? But 2024 started for us on July 1st of 2023. The state of Florida operates on a fiscal year. And so we get two New Year's holidays every year, the 1st of July and the 1st of January, but they make us work on the 1st of July one. And that's when the numbers all start to have to get compiled for the prior fiscal year. But I can tell you now over the last 6.5 months, 7.5 months, we see an uptick in both new cases and petitions for benefits. We see an uptick in motion hearings. And so the judges are busier. The system is busier, and that has the potential to affect both mediations, trials, and the discovery process that you're going through. Getting the judge's attention for a motion is going to become increasingly difficult as the volume increases. That's just the nature of business. And where has that been a real notable example? Some of you maybe have experienced in the last week or so some case reassignments. So just to explain to you what we did, uh, we decided that Orlando, even with the addition of the fourth judge when Daytona Beach and Judge Anderson were consolidated down into Orlando, the volumes of paper there, the volumes of practice there were simply more than four judges made sense for. So we looked at a lot of different scenarios of ways that we could bring power to bear, bring effort to bear on that Orlando workload. And the best that we came up with is what we did. So we took Judge Stanton in Jacksonville and we redistributed his caseload, his Jacksonville docket, between Judges Holly and Humphreys. And so that is increasing their workload significantly, but we don't think that it's doing so in an unmanageable way. And we shifted a new docket, a new Orlando docket to Judge Stanton. And so while he is still affiliated with the Jacksonville District Office, he is handling almost exclusively an Orlando docket. So I checked in with some of the Orlando judges after we did that, about a week after we did that, and they said that that made a huge difference in terms of their daily filings that are coming up on the computer. And just like lawyers have a daily filing list in EJCC, we each have one in IJCC, and we can see what's coming up from your filings, and we can manage those in a day-by-day kind of basis. So they noticed a good 10 to 20% reduction instantly in the terms of the volume of what they had inbound to have to try to deal with. So we think that's going to make a real difference in Orlando. What does that mean in terms of trials or pre-trials, anything that needs to have a hearing? Well, essentially it means that if you want an in-person proceeding, you need to speak. Look at the notice. Is a case noticed for an in-person proceeding? It should say that on the notice. If it's noticed for a Zoom hearing, you should probably be getting a Zoom link. And if you're not clear, my goodness, the best answer, if you're not clear, what's the best thing you can ever do? Easy answer, ask a question. Okay. If you want an outcome, if you want a decision, 60Q 6.115.1 says that any request for relief, that is action, will be by motion. So file a motion. Motion for what? Well, if you just want to know whether it's X or Y, file a motion for clarification. And the judge will shoot you back an order, or you'll get a call from a staff member in one of our offices telling you it's going to be in person at this location or it's going to be by Zoom. Oftentimes I have folks try to explain to me, they want me to understand that, that this is a quote, the default in workers' comp is Zoom hearings. Okay, where does it say that? I've looked and looked. I can't find that anywhere. The citations people give me that they believe say that, boy, I can't find it in there. I don't think we have a default setting. I think our default setting is we're going to deliver proceeding opportunities to you. That is the opportunity to be heard. And we're going to provide that with some notice. And the notice should tell you whether you're going to be by Zoom or in person. And you may not like the outcome that the judge has picked. So anytime somebody, I tell my college students this all the time, anytime somebody's doing something you don't like, what do? The answer is very simple. You speak up. And in a litigation practice, the way you speak up is you file a motion. You say, I don't like this. I think this should be a live hearing because we need this. I think this live hearing should be a Zoom hearing because it would be this and this. And you put that on the judge's plate. And we hope that the judge will be making case by case discretionary decisions based on your argument, based on the potential objection or feelings of the other party or parties, and making a good decision about how we're going to proceed in that particular case. Um, Time and again, file a motion, file a motion. I'm not sure why people don't like doing that. They like picking up the phone and calling. What's the problem with calling district staff and asking questions? Well, it can be okay if we're strictly on scheduling, perhaps, but too often those phone calls wander from scheduling into more substantive questions that our staff is frankly not qualified to answer, folks. And worse, it provides the opportunity for the perception of ex parte communication. The other side of the case that's not involved or engaged in that phone call, whether something substantive happens or not, they may find themselves wondering, what all went on that phone call? What all did Judge so-and-so's staff tell such and such? Um, that's a horrible feeling to have as a litigator anytime that you get the impression that someone's got an inside track. We feel very strongly about that, and we hope that you don't get that impression, but we hope that you'll help us to try to avoid others getting that impression by avoiding ex parte communication. The same is true when you send emails, and the only addressee that shows up on the email is the judge or is judge's staff. That sure has the appearance that there's one-way communication going on. So if you can avoid that, that would sure be helpful to us, and I think would help everybody in the system. What else is going on that's exciting right now? We, with the Florida Bar Workers Compensation section last week, had the opportunity to go over to that law school in Gainesville. I can never think of the name of it. Florida, University of Florida. Sorry, that was a non-humorous, mean jab at a group of people. I shouldn't have done that, but I don't know. I poke fun at all the law schools. They've all got their foibles and their strengths. But I was really impressed with the students that we had a chance to talk with at the University of Florida. I will tell you straight up that there are some fantastic young people that are going to law school. They are engaged and they are interested. Um, we had them come up after our presentation about workers' comp, and out of the 20 in the room, I would guess we had 5 or 6 that came up and wanted to talk to our panelists and to discuss with them what the workers' comp practice is really like and what they might gain in terms of experience and satisfaction in this practice. We don't need half of the lawyers that graduate next year to take an interest in workers' comp, folks, but we do need some of them to take an interest. There are folks on this call that are getting a bit long in the tooth, perhaps. I know I am. And so I'm looking for the next generation to come step up and take over these roles. I know that there are people that own law firms that would very much like to have young lawyers get some experience, grow into the ability to run a law firm and be there to buy them out, to take over running these organizations. That is true in claims management. That is true in nurse case management. That is true in the actuarial sciences, risk management, all across the workers' compensation world. People are looking for that next generation. So I applaud the workers' comp section that it is getting out and trying to talk to these folks. We've got an opportunity scheduled at Ave Maria Law School coming up soon to talk with them. We've got other schools that we're talking to. If you have an in at a particular law school and you'd like to get the section to your alma mater, we would love to get that arranged. Pick up the phone and give me a call or shoot me an email or contact Paulo Longo directly. If I haven't mentioned it, Paulo has done an outstanding job of getting folks back out and shaking hands and having interpersonal discussions and relationships. It is inspiring to see. That fella took off about a year ago with the goal of improving and promoting professionalism. And I just cannot get over the job that he's done and the many, many great opportunities I've had as a result of it. The people I've gotten to shake hands with again, their opportunities to confide and to talk and to tell us what's working and what's not working, invaluable. and it wouldn't have happened without the Florida bar. Now that said, shout out to Neil Pitts and Neil Ambacar down in Orlando, because they conspired with that's a poor word. Uh, they they uh, they worked with Paulo on the first one in Orlando about a year ago, and without their vision and imagination, we never would have gotten started. So bless them and all those that supported them. Professionalism, another great topic. If you haven't taken the Florida Bar's mandatory 2-hour professionalism class online, I have a prediction: you will. How do I know that? Um, the Florida Supreme Court last summer in July cut back the number of hours of CLE that you need. Boy, that's a huge improvement. So instead of 33 hours, I believe it was, now it's 30. And they say that's more consistent with where we were back when we enacted CLE as a requirement. A lot of folks don't feel like they get much out of CLE. I sort of get that, but I also wonder if you're looking in the right place, because I go to a lot of these programs and I hear some absolutely magnificent speakers, and I could start rattling some of them off, but that would be perhaps seen as promoting them to the detriment of others, and I don't want to do that. But there's some very, very bright people out there that show up at these programs. Many of them are on your workers' comp section leadership group, or have been, and they just do a phenomenal job of delivering their perspective. And you can take their perspective, or you can listen to what the next person on the panel has to say, but those opportunities are out there. The one in Tallahassee on March 1st is free, by the way. We'd love to see you there. If you want to register for that, I've sent out an email blast that's got the agenda and the registration information. If you can't find the registration information, shoot me an email or give me a call. I'll be happy to get it to you. But this 2-hour professionalism is the outgrowth of the Standing Committee on Professionalism. You can watch, you will watch eventually, the seminar, and you can make your own judgment about where the Supreme Court is going with this. But a couple of high points. Number one on the list was that when they surveyed lawyers in Florida for several years in a row or several years in a group, the number one complaint that lawyers have about the practice of law is the lack of professionalism. Do we see that in workers' comp? We do. Is the Supreme Court willing to take that on and actually discipline somebody for it? I think the jury's out on that. But if you're seeing unprofessional behavior, I think you need to bring that to somebody's attention. And you're welcome to drop an envelope in the mail and mail me something if you'd like to, and it's something you're just not comfortable sort of bringing forth or being known for bringing forth. I might understand that, but drop something in an envelope and send to me. If you're noticing an issue or a problem, just like with the programming, it's not working like you'd like it to, drop us an email or give me a phone call and tell me something's working or not working. Tell me what we could do better, and we'll continue to revise and work on these things as we can to make the practice of workers' comp as efficient and effective as it can be. The other thing that you get from the professionalism seminar that I think bears noticing is that there are a number of people out there that are licensed to practice law that are impolite. They lack graciousness, they lack gentility, and some of them are sort of foul-mouthed and rude. We see and hear examples of that, and I'm troubled by it. I hope that you're not putting up with abusive behavior. By the same token, periodically somebody will ask me to read a deposition. Most of the time they don't tell me why they'd like me to read it. They just call me and say, you ought to read this deposition. And I don't like saying it, but at the end of the day, folks, I'm seeing behavior by lawyers where they're less than genteel to downright rude with witnesses. They are treating doctors, our fellow professionals, without a modicum of respect. And frankly, I think some of that's starting to rub off. We're seeing doctors now in some instances who are responding back to lawyers in what we could say is less than a gracious manner. Um, wow, this system, this community cannot function without good doctors. This system cannot function without good lawyers. This system cannot function without good judges, mediators. We could go on and on. This entire process is dependent upon the interaction of these professions. And if we're not treating each other with dignity and respect, we're going to see people essentially bail out. They're going to say, well, I can make a living without touching workers' comp, and so I'm not going to do it anymore. And when that happens to the neurosurgeons and the orthopedic surgeons and I know there's lots of them, but folks, try to find a audiographic expert, someone who can do ENT and can talk about hearing loss. Try to find somebody that can do uh, infectious disease and can fulfill the requirements of being an expert or an expert medical advisor in those kinds of specialties. And from what I'm told, it's not impossible, but it's getting to be impractical. And some of that may be the hoops that we have folks jump through. Um, Boy, maybe we don't go take a doctor's deposition just because her records are going in evidence. If there's genuinely something we want to talk to that doctor about, then more power to us. But when we're going out and taking the deposition and the doctor's answers time and again are, that's in my records or that's in my report, maybe we should be getting the message from that this deposition is perhaps a waste of everybody's time. Well, the doctor charges a flat fee by the hour. I want to use my whole hour. Really? If you don't have an hour's worth of questions, you're going to make up questions about bubble gum just to eat the time and feel like you got your money's worth? Go ask the questions you need to ask. Get the testimony you need, okay? Because other than the doctor being perturbed that you've taken up an hour of her time when there were only 3 relevant questions, yeah, you've got it. You're making the other attorney in the case probably a little perturbed also. And when you put that in evidence, you're going to make the judge read 77 pages of bubblegum questions before he or she can get down to dig into that 1, 2, 3, 4 questions that is really pertinent to this litigation, the ones that make a difference. If you find that you've asked a lot of questions because it was a discovery deposition, and it really comes down to there being 2 or 3 things in that deposition that matter, why not get with opposing counsel and say, could we stipulate that we're going to put in these 2 pages, those 2 pages, and these 6 pages, and we're not going to put in the whole 78 pages of deposition? And if you two stipulate that that's what you'd like the judge to look at, well, then that's a pretty good argument that the judge will limit themselves to that. If the other side doesn't agree, is there anything that says you can't move 3 or 8 or 10 pages of a deposition into evidence? There's no such rule. Can the other side object and say the whole depo should be in evidence? Sure they can. Then it's up to the judge, and the judge can admit those other 88 pages if she wants to, or she can agree with the side that's moving the 8 pages and stick to those facts. Um, you're telling the judge how you'd like it to go. And if you're not telling, this is way beyond litigation, folks. If something's happening you don't like in the world, in the litigation, in the deposition, the way that you put people on notice is you speak your mind. You do so respectfully, you do so succinctly, and you get it out on the table. That's the only way we can sort out differences. You can't simply keep it bottled up and then go away mad. You can't blow up and scream at people. And so get those objections out on the table and say what you need to say. And then if you don't feel satisfied, my goodness, draft a motion, get it in front of the judge and get a decision. With that, I've rambled on now for 45 minutes. I promised to try to keep these to 50 minutes. I still don't have any questions in the chat room, or the chat room's not functioning. So at this point, I'm going to give one last shout out to the question box. If anybody's got a question they'd like to address, if not, I reiterate that I'd love to see you next week in Fort Lauderdale, March 1st in Tallahassee, March 28th in Miami, March 29th in West Palm Beach, or April 18 and 19 at the Forum. Great opportunity to see our nominating commission at work. Busy spring coming up. but hopefully the weather breaks and we have nice weather for our travels. I really do hope I get the chance to speak with you all in person, and I look forward to it. Well, glancing down again, I've got no questions in the box. Oh, there we are. Is there any way to watch final hearings as a young lawyer? Yes, absolutely. You want to watch final hearings. That is doable. Um, if you have a particular final hearing that you'd like to watch, contact me and I'll get you the video. If you would like to watch them in real time as they are recorded, that's a little bit more difficult, but we might be able to arrange it if you know of one coming up that you'd like to see. Whether that's because there's an issue that interests you, or whether you just notice who the lawyers are and you know that they're really outstanding lawyers. You can, oh my goodness, learn so much by watching prepared and experienced lawyers. The people that know how to do this are just outstanding at it. Some of them literally can leave you speechless, and you think, how did they get that good? Well, maybe watching others, maybe practicing. Um, but we could arrange that. I can get you recordings of particular ones if you'd like to watch them. And we'll try to work on something that's a little more widespread. The circuit courts are offering people that opportunity, and the last I spoke with our programming folks, they were trying to figure out a way that we might be able to stream those hearings. Outside of final hearings, if you'd like to watch motion calendar, the judges that are doing open motion calendar on streaming video are Judge Hedler, Judge Case, and Judge Sancerni. And if you're a young lawyer and you'd like to get experience, I learned more law sitting waiting my turn at motion hearing than probably in any other venue. You get to see a lot of great examples to live by and to avoid. And so I encourage it. So email me if I can get you a specific hearing, and we'll keep working on a more broad broadcast concept. That was the only question. And thank you again for these podcasts. Well, thank you again for tuning in. I appreciate it. I feel like we're connecting with the community. Tell your friends, tell your neighbors, and we'll put this up in the same locations as last time. There will be in the announcement blog on the website links so that you can get in and listen to the recording if you wish. Be safe, and we'll look forward to seeing you at any of these events. Have a great day.